well, we'll go ahead and get started. Thank you all for joining us for our final talk of the 2022 year. Title IX turns 50, a look at the evolution of Title IX legislation to present day practice. We have had a bit of a program change that you may be noticing. Barb Cothren is sick. She's unable to attend today's talk. She is fine, but she's experiencing some symptoms that are going to make today's talk a bit of a challenge. So we've done a bit of reorganization to accommodate this change, but please hang with us if we experience any bumps along the way. Just a few housekeeping notes before we begin. You are viewing today's webinar as an audience member, and therefore you will not have the ability to turn on your video or your microphone. Questions are encouraged and they can be submitted through the Q&A feature or through the chat. There will be some dedicated time at the end of the presentation as well to be able to answer your questions. If you have a technical issue, you can reach out to our Office of Alumni Engagement at 309-556-3145 or by email to iwualum@iwu.edu. Recording of today's webinar is going to be available to view at the Office of Alumni Engagement YouTube page, and you will be sent a link and a short survey tomorrow afternoon. But at this time, I am so pleased to introduce our two panelists. We will start with Cindy Lotz, who has served as a Director of HR and Title IX Coordination for IWU since November 2018, with over 25 years of professional experience directing all aspects of human resources and employee life cycle. Cindy has extensive experience in policy development and the application in the broader field of discrimination prevention. Title IX is a new responsibility for Cindy when she came to IWU, but the foundation of her previous work has really helped her hit the ground running. And then our second speaker is Pam Jacklin. Pam is a 1966 graduate of Illinois Wesleyan University. Throughout her professional career, Pam has worked diligently to champion the rights of all by consulting and assisting in Title IX legislation. In 1972-73, just as Title IX was being passed, she was an officer of the American Political Science Association's Women Caucus, and she later worked with a coalition of groups, including the ACLU and the new National Women's Law Center. In the fall of 1973, she was named the first Director of Affirmative Action and Women's Programs at Washington State University in Pullman, Washington. And while at Washington State, she's also served as trainer for the National Women's Law Center, which offered a series of regional trainings on Title IX and the development of law concerning sex discrimination. She went on to be a consultant to the president of the University of Idaho on Title IX. And additionally, she represents a variety of plaintiffs with Title IX complaints against schools, colleges, and universities in Oregon in both court and administrative proceedings, invoking federal law and/or Oregon's own Title IX type laws. And at this time, I'm going to turn the discussion over to Pam, who can get us started. Oh, Pam, you're muted.
Sorry about that. I'm glad to be here today to talk about Title IX. It's a very important law, and I think my work on Title IX is in some ways my proudest professional accomplishment, even though much of the work was early in my career, but it certainly had impacts beyond my day-to-day law work that I did later in my career. Title IX is a really interesting law, and its history is very interesting. Today, it is primarily known as the law that changed athletics. And that's understandable because it has had an enormous impact on athletics in the United States and around the world, actually, which is just, most of you know, you see the fruits of the change already. It's also playing a much more important role today in issues like sexual harassment and most recently gender equity. And as we expand our view of what constitutes sex discrimination, new areas are coming in, making Cindy's life more challenging, for sure, in terms of trying to see that the university is in compliance today. but luckily she's working with a good client, and that's always a helpful factor to have people who want to do the right thing on your side. And my sense is that Illinois Wesleyan has been on that track for a long time. But let's talk a little bit about how the law got passed and why it came to be. First of all, most people don't understand that when the law was passed, the people who were pushing it were primarily concerned with professional women and educators. We were concerned that we were allowed in general to go to colleges and universities, but that once we got out, we didn't have opportunities on the job market. I routinely watched our bulletin board job opportunities, many of which said women need not apply. It was a given. I went to a graduate school, the Fletcher School of Law and Diplomacy, which I love dearly. And when I went, there was a 10% quota on women. And they weren't apologetic. They were proud because it was the highest quota on women of any of the well-known, there were only about 3 graduate schools of international diplomacy. So it was a different world. Our dean began his first greeting to the students saying, I see the 10 women out there and I hope you all find husbands here. And that was in essence sort of the view, as we were there to be good wives to the future diplomats and businessmen who were going to do international things. 6 of us did, I'll say, but that's another matter. But going back then to this point in time, women's caucuses, the women's movement was beginning in the late 60s. Women's caucuses were starting to form in all of these academic institutions. Groups like the National Organization for Women, the National Women's Law Center were just starting up and trying to figure out how to get a handle on addressing women's rights issues. So what you need to understand about any legislation is there are certain preconditions, and one is finding the right time. And in this case, the right time was the late 60s, early 70s, because women had come awake in 1964 during the lobbying and passage of the 64 Civil Rights Act. Now that was the seminal act, Lyndon Johnson's magnificent legislative victory, something John Kennedy had not pulled off, to provide African Americans with some basic civil rights. And the Title VII was the employment provision, and it prohibited discrimination on race, color, national origin. Some of the Southern senators opposed it directly, but others decided that they didn't want to oppose it directly. They wanted to find a more stealth way of getting that law defeated. And one representative came up with the brilliant idea of amending it to include sex discrimination, because he thought that by putting sex discrimination in the 64 Civil Rights Act, it would be so obviously ridiculous that no one would pass it. Unfortunately for him, that didn't happen. Not only was President Johnson about to give up on his effort, but there were some women congresspeople who said, we like this idea. And they stepped in to support it. And it did get into the law, even though it was still largely viewed by people in authority as a fluke and not to worry about. So when various agencies, including the Equal Employment Opportunities Commission, started enforcing the Civil Rights Act, they paid almost no attention to sex discrimination because they had a mission. And certainly race discrimination was a major, major problem that they did need to pay attention to. But it took some of the women who were professionals and executives and teachers by surprise, because now this was the law of the land, and why was it being ignored? This is happening at the same time that we are hearing again about the Equal Rights Amendment. And it was this period of time into the early 70s when we almost got the Equal Rights Amendment ratified. But one way of promoting the Equal Rights Amendment by women's groups was encouraging President Nixon. We had bipartisan relationships that worked to a great degree in that era. President Nixon to appoint a commission on the rights and responsibilities of women, which he did. In 1970, that commission, it was actually a task force, issued a report called A Matter of Simple Justice. And it spoke to not only the Equal Rights Amendment, but implementing legislation that would be necessary, and suggested some very sophisticated types of laws that might help make the Equal Rights Amendment, make equal rights a reality, assuming the Equal Rights Amendment would be passed. But the brilliance of this was that these laws passed in the interim when we were looking at women's issues, even though the Equal Rights Amendment failed, and they still provided us with an ability to move forward. So what we saw then was Representative Edith Green step forward and say to herself, this is my time, I can do this. She was a very important member of Congress, had been there quite a while, was viewed as being a tremendous debater, a smart intellect. A lot of the men didn't like her. They made lots of disparaging remarks about her because they thought she was too masculine, i.e. She spoke up, she did not put up with any bull. And that was not well received in Congress. Women were supposed to be ladies and do what the guys wanted. So she was an outlier. But she had enough power to become the chair of the select subcommittee. There were no women chairs of committees, but she was the chair of a subcommittee on higher education. That gave her a forum. And to get legislation passed, you have to have the right time, which we've already talked about. And you have to have the right vehicle. And the vehicle here was the Select Committee on Higher Education. So that didn't stop her from trying to get a law passed that addressed all of education, all of our education institutions, pre-K through graduate schools, but it did make the emphasis go on higher ed. But Mrs. Green was, as I said, she was a very good strategist. She realized that while the report on simple justice talked generally about discrimination against women in America, it wasn't focused on education. It didn't have enough documentation of problems, particularly in higher education, to support the legislation and allow her to get the kind of congressional support she needed to get this passed. And fortuitously, she became acquainted with a woman named Bernice Sandler, a PhD in psychology, who, when she had applied for a position after getting her PhD, very strong academic credentials, generally viewed as being brilliant, was told she wasn't considered at all, because she should recognize she comes on too strong for a woman. This was her aha moment. She had not thought about discrimination in education up until that time. But she started doing some research and looking around. She was shocked that there were no laws against discrimination in education against women. She then stumbled upon a little known fact, which was that there was an executive order that President Johnson had first signed, I believe in '66, addressing discrimination by federal contractors. That is, anybody who receives federal money in order to do something becomes then a federal contractor and has to, to do business with the government. To get this contract, you have to follow certain terms and conditions, one of which was non-discrimination against people on the basis of national origin, race, and color. And some women's groups who knew about this executive order before Bunny Sandler, as she was known, had pressured President Johnson to amend it and add sex discrimination, since that was also part of Title VII. They succeeded in 1967. And Bunny found this out, and she said, we could file complaints against colleges and universities for discrimination against women in professional and graduate programs. And she started networking with people all over the country. This is before we had social media. I mean, this means you're writing letters, you're calling people, you're talking to your friends. Do you know somebody at this university? And then getting a contact and reaching out to them. And she got groups in a lot of different universities to start gathering data about women on faculty, women in instructional positions, how women were paid compared to men, what kinds of offices they had, what kinds of caseloads they had. Generally, the women were required to teach more, paid less, and various other things, and hired in very small numbers to start with. So she gathered this data, and she and Mrs. Green were both on the advisory board established by a woman named Betty Boyer, who had founded a group called the Women's Equity Action League. And it was, her advisory board was really blue chip, and it carried legitimacy and credibility. Betty was on it, of course. Bunny Sandler was on it. Edith Green was on it. Martha Griffiths, another congresswoman, was on it. Arvon Fraser, who was the administrative assistant, the top legislative assistant, the top person in the congressman's office, and her husband, Don Fraser, was a congressman from Minnesota. She had extensive relationships with people on staffs, both in the Senate and the House, which became critical to pulling in support. Birch Bayh, who became the senator who Edith Green had lead the effort in the Senate, so they were co-sponsors, and some other important people who also supported the development, all were there. So they networked. So you had this networking and you had this marriage between the legal strategist who knew how she could run a bill and she had the power to do it, and the newly honed feminist who had the data, who could provide the material for hearings, which would set the basis, factual basis for the legislation. So Edith Green held a full week, which is a long time for hearings in the House or Senate, full week of hearings on the subject of sex discrimination against women in higher ed, using Bunny as a star witness, using the documents she had, using her connections throughout academia, and pulling in people both in academia and people in Washington, D.C., and the new women's groups like the National Organization, National Women's Law Center, for example, and others, to come and testify. And it was a very strong performance. Then Edith Green hired Bunny Sadler to put together the record into one document that became the sort of Bible of discrimination against women in higher education, and got 6,000 copies made. Usually you're about maybe 600 at most of a congressional hearing actually made. And of course, in those days, you couldn't go online and find the results of a congressional hearing. You had to go to a library and find it, or have a copy sent to you or something. And they sent it around to universities. They sent it around to various people in influential positions, to people throughout the Department of Labor, throughout the Department of Education. And this became a mechanism for people to say, okay, we get it. We need to do something about discrimination against women. So the next thing is, how do you strategize the bill you're going to put? What are your foundational premises when you put it together? And what women's groups encouraged Mrs. Green to do, and she initially was thought this was a good idea and pursued it, was to essentially replicate Title VI of the Civil Rights Act of 1964. Title VII, as I said, was employment. There were other titles about public housing, public transportation, various other things. But Title VI was the education section of it actually was broader than education, but it was the education section because it said any programs that are federally assisted. So programs that get federal money, such as the federal government gives money to the state and to school districts, and the state and the school districts then spend that money for student assistance, for providing food for them, for providing curricular materials, for whatever the federal government says they should provide it for. But a condition of getting that money is you're not going to discriminate. And of course, Title VI said you won't discriminate on the basis of ethnicity or color or race. So Mrs. Green thought, okay, we'll just write that general law. We'll amend Title VI. We'll go into the Civil Rights Act and we'll amend Title VI to say, and sex discrimination. Well, early probably during 1970, I may have my dates slightly wrong here, but around that time, African-American leaders came together and came to Mrs. Green and said, we support the idea of sex discrimination being unlawful in higher ed or in education in general. But we are very worried that if you open up Title VI, you are opening a can of worms. And the people who still oppose civil rights for African Americans and other racial and ethnic minorities will come in and try to put all sorts of amendments and exceptions and gut that law. And that was a risk. And so Mrs. Green decided, she was the person who was dealing with the strategy. She decided, I understand that, we're not going to do it. There was a new law that she was shepherding, also a broader law that dealt with a lot of kinds of financial assistance to higher ed. That was it ended up being called the Education Amendments of 1972. And it was an amendment of the Higher Ed Act of 1965. She said, we'll just make this a part of that act and it'll be standalone sex discrimination. So Title IX, it became Title IX. I believe that's the last title in the original law. And it just said, oh, by the way, to get all this money for all these good things you want, you may not discriminate on the basis of sex if you have federal money. So this covered public schools, all of which got federal money, and virtually all private schools, which got federal money. I remember at the time that I think Bob Jones University was the only university at that moment that didn't take federal money and therefore could continue. They did it because they wanted to continue to discriminate on the basis of race. And they could therefore continue to discriminate on the basis of sex because they were not covered by Title IX at that moment. And there are still a few schools. Hillcrest College in Michigan, as of the 1990s, wasn't taking federal money. I doubt they're taking it now. I don't know though. So we got this hook is through the money you're getting from the government. Educational institutions looked at that and they said, I wonder if we should be worried about this. But they were really eager to get all the money that was being provided. And the general counsel of the American Council on Education said, well, actually, we don't need to worry about this because it won't cause much trouble because there is no discrimination in higher education. He apparently hadn't read the record of the 1970 hearings, but this is a lesson. We always think that as people make the comment that ignorance is bliss, and sometimes ignorance is bliss. In this case, it was bliss for the women's movement that wanted this law passed, that the higher ed people didn't understand how much discrimination was being enacted by them. They saw themselves as above any possibility of discrimination because of their intellectual position. But they thought, there are a couple problems here that could make difficulties for us. And the primary movers in trying to get exemptions to Title IX started with the Ivy League colleges. Dartmouth, I think, actually led the way, but Harvard and Yale and Princeton were in there, as well as some of the other schools and some smaller schools. And they were very concerned about undergraduate admissions, interestingly. They didn't want to argue against equality for women, or non-discrimination, I don't mean equality, I mean non-discrimination against women in admissions to graduate programs and professional programs. They didn't think that would amount to much. And you can tell why they didn't think it would amount for much when you listen to their reasoning, what they expressed to Congress at the time. They said, look, a lot of our women who come to our schools are just here for their Mrs. degree, their MRS. They just want to get married, and this is a nice place to spend a few years and meet the men who are going to run the nation. And it's for that reason that they come. And it's fine to have some of them there because it can make the environment a little more diverse and more interesting. And the young men like having young women nearby, whether it's like Harvard and Yale did it with separate, well, Yale was all male, but they had relationships with Vassar College at that time, which was all women. Harvard did it by having Harvard College and Radcliffe College. Radcliffe College was much smaller and for women, and Harvard was much bigger and for men. And they said, if you make us admit women on the same terms and we can't set quotas, it will totally upset the balance of our classes and such, and it will degrade the quality of our students. And it will change the nature of our schools. It did change the nature of their schools, but it did not degrade the quality of their students. But those were the arguments. So they said, we want an exception for undergraduate private colleges admissions. And Mrs. Green thought about that. And she said, I can live with this. They can cause me a lot of trouble. They have very powerful lobbying networks. If I give them what they want, I get all colleges and universities, public colleges and universities, which have more students. Plus, I get graduate and professional training, which I care about most, personally, just cared about most. And we have from kindergarten up. We can create more women. Change will happen, even with this exemption. And she was absolutely right. So she accepted something that for many of the feminists, particularly people my age, new feminists saying, how can you allow that exception? but she was right. It also, therefore, allowed an exception for single-sex schools, traditionally single-sex schools. So if you were an all-women's college, you could stay all women. If you were an all-men's college, you could stay all men. And that actually, some of the feminists wanted. Their feminists were divided between whether you should be able to have women's colleges as a kind of affirmative action. And the Catholic educational establishment definitely wanted to keep all women's colleges because they had small ones, but they had more than anybody else. And the nuns ran them, and the nuns wanted to run their own colleges. As one person joked, I think at the hearings, that if you didn't count nuns as presidents, the nuns who were presidents of colleges and universities, there were more whooping cranes in the United States than women presidents. Whooping crane was obviously a bird that was going extinct at the time. So that was a consequence as well. So there was also an exception. The exception encompassed the right to continue single-sex colleges. As you all know, there are only a handful of single-sex colleges left. The movement, the women's movement and the education movement that was prompted by Title IX led to most of these schools choosing voluntarily to become co-ed. And there are a few holdouts who believe women's education, we have full equality, and we haven't gotten there yet. So they still exist. So we had those exceptions. Initially, the legislation, Mrs. Green wanted it to amend Title VII as well, because Title VII, while it covered employment broadly, didn't cover employees who were teaching employees or employees working on educational activities at colleges and universities. That was an exemption that had been put into Title VII. And so that exemption was cut out of Title IX, but moved back to a different committee. The committee chair said, hey, that should be mine. And he wanted to push it through. So she said, fine, you take that one. And it passed also in 1972, when the education amendments of 72 became law. So I think those are the major exceptions to the law. There are a few others, but those are the major ones that you need to understand and count. So we passed this law 1972 in June. The Equal Rights Amendment was sent out to the states for ratification by a resolution in July of 1972. So you see the convergence, this being the right time. But then, oh, excuse me, I forgot one other thing that went into the congressional record before the act was passed, which was important. And that was some people in the Senate, when it came up for debate in the Senate, some of the senators had been talked to by some athletic directors, and they said, is this going to harm football? This could, you can't have women on football teams. This is going to harm football. And so they talked among themselves, and Birchby, who was leading it, and they decided to have a statement or two put into the record by people who were supporting the law, saying, don't worry, it's not going to result in women on football teams. And that was also in the congressional record, was not written into the law. And they managed, the higher education community thought this law was sufficiently harmless enough that they let that go through as it was. Then HEW, which was the Department of Health, Education, and Welfare, it's before they were separated and education became a separate department, was asked to write regulations. Well, that process became a huge political storm that took 3 years before regulations were set forth, and another 2 years before any provisions regarding athletics went into effect. And so 73, 3 years for the 72 to 75 for the regulations, and then there was another window to try to get in your athletic program in shape under the regulations. But during that year, those years, there were very, very strong lobbying by women's groups of HEW and of congressional people to make sure that there would be no takebacks through amendments to the law or subsequent legislation. And there was also a huge effort that the NEAC, I'm going to do this again, the NC2A pushed and tried to get an exemption for revenue producing sports, which they broadly defined, but clearly they had in mind basketball and football, and at some schools they had other sports in mind too, because they argued, it was interesting, they argued at this point that football and basketball at the college level was revenue producing because it produced so many donations. This was you had ad money in those days, but nothing like you had today. So the actual third-party dollars coming in, nothing like it is now. But at that point, they said, we're really sort of a business, which was interesting because they were walking on a very thin ledge, because if you are a business operated by an educational institution as opposed to an educational activity, you're taxable. And somehow, I have always wanted to take that case on, but somehow nobody had the resources or time to do that and challenge that premise. And over time, the law has been maintained. The courts have upheld the law as written and not found that they should read into it an exception for major sports. So that's in a nutshell. I don't know how I'm doing on my time, Kaylee, so you need to tell me whether I should add any other details or just let Cindy go ahead.
I was gonna say, I think Cindy had covered, it's gonna cover the more present action and application to IWU. And so Cindy, would you like to go and then we can come back and talk through some more like litigation cases? Does that work?
That sounds great. Pam, thank you so much. That was such interesting information. And I have not had access to the inner workings of how Title IX has unfolded before. And so I really appreciate your expertise. I'm gonna ask for just a little bit of grace about the fact that I have terrible lighting here. I'm at home because I have been battling influenza, and so I apologize that there's glare on my glasses and the lighting is horrible. My lamp that I usually use to help with the lighting just burned out as we started the presentation. So my apologies for all of those elements. So, you know, Pam's given us a really good description of how Title IX has progressed over the years. And, you know, in 1972, we know that it was affected to protect people from discrimination based on sex in education programs or activities. The focus was initially very narrowed in on equality and access to education and athletic programs. But then from the mid-70s until the later 90s, the Title IX front was fairly quiet. And so I'm going to start in 1997. The Office of Civil Rights provided guidance as a result of years of enforcement of Title IX. They published a document titled Sexual Harassment Guidance, Harassment of Students by School Employees, Other Students, or Third Parties. And because based on the years of enforcement, OCR had determined that a significant number of students, both male and female, had experienced sexual harassment, which either interfered with or affected the student's academic performance and emotional and physical well-being. OCR at that time proclaimed that the elimination of sexual harassment of students would be its top priority. From this point forward, the focus of Title IX became more closely aligned with what we understand today as a prohibition of any discrimination on the basis of sex, or as we've evolved to today, based on gender. In the 1990s, the Supreme Court held that students can sue for student-on-student harassment under Title IX, and schools are liable for damages if the harassment is so severe, pervasive, and offensive that it interferes with the victim's educational environment. And you know, I'll point out this is an interesting departure from Title VII that Pam has mentioned earlier. So Title VII prohibits employment discrimination based on race, color, religion, sex, and national origin. It uses a standard of severe or pervasive or offensive. But in Title IX, the definition uses the word "and," which is an interesting disparity in the definition of harassment. So what the Supreme Court found is that if the school knows about the harassment and its response is clearly unreasonable under the circumstances, it can be held liable for the damages. So in April of 2011, during the Obama administration, the U.S. Department of Education, Office of Civil Rights, released a Dear Colleague letter, which issued new guidelines to institutions of higher education and defined how they needed to handle sexual harassment and sexual assault complaints filed by students. These provisions included, it established the school's obligation to respond. Previously, schools had been allowed to use a clear and convincing evidence standard, and it established the preponderance of the evidence as a potential standard. So that the new standard introduced suggests, I've heard it referred to as 50% plus a feather. So in other words, you're more than 50% certain that the person is responsible for the prohibited conduct. It defined prohibited sexual harassment as unwelcome conduct of a sexual nature, including unwelcome sexual advances, requests for sexual favors, and other verbal, nonverbal, or physical conduct of a sexual nature. It included that sexual violence is a form of sexual harassment prohibited by Title IX, and suggests that the prohibited harassment or discrimination interferes with or limits a student's ability to participate in or benefit from the school's program. The Dear Colleague letter required schools to publish a notice of non-discrimination and adopt and publish grievance procedures. So in response, Illinois Wesleyan University assigned a committee made up of a broad swath of constituents to work on developing a comprehensive Title IX policy. This policy guided the university's responses on Title IX matters for, basically the next 10 years. Subsequently, in 2014, additional guidance was published, and the document Questions and Answers on Title IX and Sexual Guidance was published. It suggested and made clear that schools should process all complaints of sexual violence regardless of where the conduct occurred, to determine whether the conduct had continuing effects on campus. Schools were expected to address those continuing effects by providing appropriate remedies for the complainant and, where appropriate, the broader school population. This meant schools were required to provide remedies even for sexual harassment that they had no power to prevent. So in the 2014 Dear Colleague letter, harassment or discrimination that occurred outside of specifically the educational program or activity was covered. So that was the 2014 guidance. In 2017, under the Trump era, a Dear Colleague letter was published that withdrew the 2011 and 2014 documents. So if you think that complying with Title IX is confusing and complex, you're absolutely right. The Dear Colleague letter, in general, suggested that due process rights of a respondent were not protected in the earlier documents. It suggested it disagreed with a number of elements of the earlier guidance. It included disagreeing with, it didn't support allowing complainants to appeal a not guilty finding. Regarding cross-examination, the previous documents held that the right to cross-examine a complainant would, in and of itself, violate that complainant's Title IX rights. And the 2017 document suggested that that was inappropriate. Under the 2011 and 2014 guidance, due process protections to accused students could not unnecessarily delay resolving the charges against them. 2017 suggested more focus should be given on due process rights for a respondent to a Title IX complaint. The 2017 document reflected concern that the earlier guidance led to a deprivation of rights for both the reporters of a Title IX complaint and the responders. And it suggested that the department in those documents imposed regulatory burdens without affording notice or opportunity for public comment. So the document underscored the ambiguity and the confusing mix of legally binding requirements and best practice suggestions in those earlier documents. Illinois Wesleyan continued to operate under its first developed policy, because while the earlier guidances were withdrawn, the 2017 withdrawal also didn't have the force of law. Then a year later, a notice of proposed rulemaking was issued. The rulemaking process was extensive and its response to comments was in depth. The final rules, it's been suggested, return to the legal framework established by the Supreme Court more than 20 years ago. It was the first full rulemaking on a major Title IX issue since 1975, and the only one dedicated to sexual harassment. And in 2020, the final rule was published. So for the first time, the department's Title IX regulations define that sexual harassment, including sexual assault, is unlawful sex discrimination. The department previously addressed sexual harassment only through those guidance documents, which were did not carry the force of law and did not have the force and effect of law. Now, the department's regulations imposed important legal obligations on schools. It includes prompt response to reports of sexual harassment. The 2020 rule requires equal access to supportive measures to both a complainant and a respondent. These measures were meant to restore or preserve equal access to education, protect students and employee safety, and to deter sexual harassment. The 2020 final rule respects complainants' wishes and autonomy by giving them the clear choice whether they want to file a formal complaint under Title IX, separate from their right to supportive measures. The final rule also provides a fair and impartial grievance process for complainants and protects complainants from being coerced or threatened into participating in a grievance process. So the final rule, another important aspect is it defined sexual harassment as a school employee. The first element is quid pro quo. And if you're not familiar with that, in Title IX, it suggests a school employee may not condition an educational benefit or service on a person's participation in unwelcome sexual conduct. Again, often called quid pro quo harassment. Prohibits unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education or program or activity. And sexual assault, which includes dating violence, domestic violence, or stalking. And those offenses as they're defined in the Clery Act and the Violence Against Women's Act. The final rule from 2020 requires the institution to allow both parties to select an advisor who can provide support throughout the process. It requires live hearings with the provision of cross-examination. Those were determined to be crucial to allow due process for both parties. Now, I'll mention here, critics have argued that this threatens to re-traumatize complainants and discourage the reporting of misconduct, and that gives an unfair advantage to those who can hire a lawyer as their advisor. And the other thing that the 2020 final rule did was prohibited the single investigator model. In the single investigator model, a single individual would investigate and then determine if the respondent was responsible for violating the Title IX law. Prohibiting that model was intended to provide fundamental fairness, requiring that decision makers be free from bias that could occur during an investigation process. Required the decision makers to review the record created by the investigators and also to hear live testimony. So Illinois Wesleyan University's response, we published our first policy revisions in August of 2020. And our goals with those were to comply with the 2020 regulations and to protect the integrity of our care and respect for students, which I think just is demonstrated so so well by the work that's done in the folks that manage investigations and the conduct hearings that are a result of a formal Title IX complaint. So let me think. I will also mention, I will back up and mention from the previous slide, in August of 2022, Illinois Wesleyan developed an updated Title IX policy. We found that the work that had been done in 2020, and if you keep in mind, at the time, we were in the midst of dealing with all of the ramifications of COVID when the final rule was published. In 2022, we took our base policy, and instead of just bootstrapping on the regulations required by the 2020 rule, we more clearly defined what the university's responsibilities are and what the students' rights are in a Title IX case. So where are we today? 2022. We have a new notice of proposed rulemaking. In June of 2022, the U.S. Department of Education released a notice of proposed rulemaking. It suggests that the proposed amendments will restore crucial protections for students who are victims of sexual harassment, assault, or sex-based discrimination, and suggests that's a critical safety net for survivors that was weakened under previous regulations. It listed 11 key goals. And I think another important provision is it makes very specific that the protections of gender-based discrimination, depending on the era, gender-based discrimination or harassment was either determined covered under Title IX or not. And in the notice of proposed rulemaking, it suggests the next rule will clearly define protection from discrimination based on gender. So that's where the law has come from. That's how Illinois Wesleyan has responded. I think I can't leave my portion of this program without saying that it is complex and but such vital work. And nobody goes into human resources or Title IX work because they want boredom. And when you work with issues that are so crucially important and vital to student success on campus, we heavily rely on a very close partnership with the Office of Student Affairs and with the Office of Academic Affairs and Human Resources, working so closely together to ensure that we follow the regulations as we're required to, but again, that we also protect all of our relevant constituents in the best way possible, in ways that provide respect and care and concern. So I would say that I will stop sharing, and Kaylee, I'll let you carry where we go from here.
Right. Well, we have a little bit of time here, and before we turn to questions, Pam, I think you have some litigation examples maybe that you could share with us.
I do. When you said, can you give me an update? Okay, I see on time. A few minutes, right. I just wanted to add something, and it's a little bit going back because it's covering primarily this period where you were not expanding the scope and the understanding of Title IX or fundamentally changing the regulations, which Cindy has so well described for you. And it is very complex. As a lawyer, most of my career, I did a lot of work in employment law and was often representing either employers, educational institutions, or other employers who had problems with the various civil rights laws and finding ways to implement them appropriately and fairly. And I recognize and applaud people who do this work all the time with respect and care, because it's really crucial. But during that period, after the initial period when the act was passed, litigation began around the country dealing with athletics issues. And in fact, athletics, there had been a fair amount of discrimination even before Title IX, often based on either state laws or on the 14th Amendment of the United States Constitution. But up until 1971, the 14th Amendment had never been implied by the Supreme Court to find any sort of discrimination against women unreasonable. So it was because of laws like Title IX that put new air into the efforts to use the 14th Amendment as a legal basis to challenge discrimination, although many of the cases that were brought did actually rely on Title IX itself, after there was actually a several-year period before which the court ruled that you could bring a private litigation action under Title IX. There was a string of cases that found you couldn't, which was eventually overturned in a case involving the University of Chicago, where they said that the intent of the law was to imply a private right of action, and it was interesting because that was an issue that, as being around at that time, those of us who were looking at the law and analyzing the law thought that was sort of a slam dunk, because Title VI had been held by the courts to have a private law right of action. So we thought, well, we based this on Title VI. We ended up taking it out of the Civil Rights Act and putting it into the Education Act, put in a couple of exemptions, but it's essentially the Title VI for sex discrimination. So of course there's a private right of action. Well, we found out that it took a long time and a lot of money to make that happen, but it did. So I personally was involved in the Northwest, because by then I was based in the Northwest, and I've been at WSU, Washington State University, for a number of years, as was mentioned in the introduction, and then moved to Portland, Oregon, and joined a private law firm. And as we're always allowed to do pro bono work, because I was interested in Title IX, and I had come to believe during the process of helping lobby on the regulations with HEW, that if we didn't solve the problem of discrimination in athletics, we would never get to a point where women could have true equality, because there's so many psychological overtones that were at the time, fewer now, but they still exist, about the proper roles of men and women, and particularly that played out in the field of athletics, of what was right, what were the right sports women should play, compared to, should women only be allowed in certain sports or all sports? Should they ever be allowed in any contact sport? There were just so many issues that went to the heart of how we try to define what a man or a woman is, that I thought this was really an area I wanted to work in. I think all the gender work that's been done since then really is aimed at the same concern about our understanding of what makes a human being, and how we are similar and different in so many ways, and how the law should deal with that. It's endlessly interesting to me, at least. But for that reason, I chose athletic discrimination as an area to deal with. And there were sort of three seminal cases that I was involved in for the West Coast. And they had influences beyond the West Coast, but they were more important here because everybody knew about them. And they were Blair versus Washington State University, Aiken versus Llewellyn, which is against the University of Oregon, and Peterson, the Peterson versus Oregon State University. Peterson happened, Blair is a story that started when I was at WSU, so it's really a story from 1973 until the final court decision in 1987 by the Supreme Court of Washington. And I may take a few minutes to tell you about that. Aiken was a case where the parents of two twin girls who played basketball at the University of Oregon, the parents were just outraged by the differences of treatment of male and female athletes, and started a case. And all I'm going to say about that one, I was involved not at the very beginning, but from the time I joined my law firm in 1979 on, I was involved. And I will point out that we were negotiating throughout this period a temporary settlement. Well, we had a court case, and then a Court of Appeals case, and a remanded case back to the courts. The university had won some points that were contested by us on appeal, and they came back, and we started to try to negotiate with the university again. And just because this case was pending, I would suggest to you, the difference in spending by the University of Oregon went from $240,000 for all women's programs in 1978 to 662,500 in 1979. Now, that didn't bring equality, but it showed a substantial impact of concern because of this litigation. By then, the university understood the possible impact of these kinds of cases and wanted to be able to be sure to show that it was taking measures, taking not insignificant steps to address the problem, even if they were not steps that satisfied the plaintiffs. Peterson was interesting because a colleague of mine in the bar in Oregon, Cindy Barrett, and I filed an administrative complaint under what we call the state Title IX, the mini Title IX that was passed by Oregon after Title IX was passed, to parallel the language of Title IX and there are some differences, but to try to get the same issue, eliminate discrimination in education against women. And we filed that complaint in January 18th, 1980. We filed the complaint. And we had as plaintiff the entire softball team that had just won a major championship. And the baseball team had been doing horribly, but the softball team was getting a pittance as compared to the money that was spent on the baseball team. And they always said, well, there was difference in, granted, there was a difference in the level of play at that point and in the competition, but in their leagues, the women were doing extremely well and the men were doing very poorly. You see that replay with the national US soccer team in the last decade and how that has influenced change for women's soccer, that the women were doing so well. Well, this softball team was doing that for us back in 1990 at Oregon State. So the plaintiffs were not just the team members, but we picked out certain members of the public. My co-counsel was great at that. She got a very strong proponent of women's rights who worked for the Office of Civil Rights Division federally. And she got a couple of lawyers, a lawyer's wife who was a good friend of ours, and her brother and sister-in-law to be taxpayers, saying essentially, we're bringing our standing is that we are taxpayers. We don't want our tax money used for discriminatory education policies, which was an interesting theory. And we decided we'd add that on to the Title IX claim. Within the period of about 6-7 months, we managed to come to a settlement agreement with Oregon State. And it was based upon all the work that had been done by people, and by which I had done myself at Washington State, in understanding how you create a self-evaluation of Title IX compliance and what the detail, the facts, the really getting down into the nitty-gritty to say, this is what we need to do. And also how you can change. The basic premise of most of the work that I did, this was not true of all the cases across the country, was to get a foot in the door with an institution, to convince them that they were really in seriously out of compliance and in trouble. And that what they needed to do was start, not at their, with all deliberate speed, rectification of these problems, but to really move more quickly and to make alliances with the groups that could help them move more quickly, because we would then give them some latitude. So I was entering settlements that were not equivalent to what I thought women had the right to gain over time. But none of these settlements precluded future women from making claims. What they did do was start moving the universities toward the right position. And in the case of OSU, within 6 months, they got rid of their legal bills. That's a big thing. We are all doing, the women on the women's side, we were doing this for free. Now, we got paid by our law firms to do other work, but we were doing this for free. But we worked out a whole scheme where we had teams that were now in the national level, football, basketball for men, both of them. Teams that were on a, and were revenue producing, were actually positively contributing to the revenues. Those were only football and basketball. Teams that were on a national level of competition and might be bringing in some money, but weren't really, they certainly weren't paying for themselves, much less contributing to other sports. And at Oregon State at that point, that was wrestling, women's basketball, and women's gymnastics. We looked at teams that could compete within the Pac-10, We looked effectively. We looked at teams that only could compete within the Northwest, Idaho, Washington, Oregon. And we looked at teams that were local, that were the quality of their play and competition was essentially at the local level, and that was golf and tennis. And we put them all in different levels and then had looked at the comparisons between men and women in each of those levels and insisted that they be equal. We also had strong commitments to try to move women's teams, at least one within 5 years, up to the level of actually revenue producing, moving at least two up to the national level where they were contributing revenues and such. And it would take extra development, extra training, extra money for equipment, extra money for facilities to do all of these things. And the school committed to spending that extra money preferentially on these women's teams to give them a head start, because they had been doing this forever for the men's teams until they started. They didn't get to the point where they were producing massive revenues on their own. It took a lot of support and subsidies. And so that was the approach we took. And the school, and it was interesting, both counsel for Peterson and Aiken in Oregon wrote a law review article together, urging other councils to look at what they were doing and what we were doing in Oregon as a roadmap for the future, because it essentially allowed you to buy time to get where you were, even if the law was going to be interpreted not to buy you time, because there's the practical realities that we all know. It takes time to make change like this. Blair started, do I have a minute on Blair, or are we done?
We're getting a little close here, and I want to have time to each ask you. I have some good follow-up questions that I've asked.
We can stop. I can talk about Blair if somebody wants me to in a question, otherwise we'll skip it.
I know this is, I mean, clearly we're learning. We could have had like a 4-part series on this. I mean, it's so extensive, such extensive work. So, Cindy, we did have a question here. Could you, I know a brief maybe summary here, because this is probably pretty extensive, but could you walk us through a brief summary of the process of a Title IX investigation here at IWU? Like, what are the steps that takes?
Sure. So it starts with a complaint coming in. So a sexual, we've published our policy as a sexual misconduct policy. If you look at our Title IX page, because we want to follow one all-encompassing policy, whether something meets that very high standard of Title IX violation, or whether we consider it to be simply sexual misconduct. Having one umbrella policy also allows us to manage all types of complaints under the same kinds of steps. So a complaint is filed. Usually, the majority of the cases in the 4 years that I've been here are student-on-student complaints. And a complaint is filed. Generally, it comes in through student affairs, and the intake person counsels the individual. That, again, the new regulations, the 2020 regulations, define the complainant as the person making the complaint, the respondent as the person responding to the complaint. And student affairs in that case then guides the student on what their rights are under Title IX, that they have a right to file an informal complaint, and then the issue will be handled as a student misconduct problem, or if they want to file it as a formal Title IX complaint, which requires a complaint in writing that gives the basics of the allegation in order to let me as a Title IX coordinator know if the allegation falls under the Title IX regulation or whether it has to be dismissed. If it becomes a formal Title IX complaint and an investigator is assigned by me, and being a small institution, sometimes I will be the investigator. The complaint is investigated, witnesses are questioned, any corroborating evidence that either party demonstrates is collected. And then when it moves to the grievance, the end and the grievance process, a hearing is done by our All-U University Judicial Committee, AUJC. So AUJC gets to see all of the evidence that's been collected and read all of the evidence and any documents submitted. They do the live hearing, and then they make the determination on whether the respondent is responsible for violating Title IX. I'm sure that I have left out important steps. I will talk about supportive measures. I think I can't walk away from this discussion without saying that early on, when the intake process happens, the complainant is immediately offered supportive measures, which might include, for example, a no contact agreement that would be initiated between the two parties, might involve rescheduling of one or the other of the parties if they're in a class together and that doesn't seem comfortable. So supportive measures are immediately afforded, and at the point that the complainant wants to make it a formal Title IX complaint, that's when both parties receive an official formal response from me, allowing all of the rights and responsibilities under Title IX. So there you go.
Well, I think they can find a lot of these resources too, if you're more interested in IWU's policy, on our website as well. And so, I mean, that's another really great resource as well, if you're curious a little bit more about IWU's current policies and practices. All righty.
Can I ask Cindy a quick question?
Yeah,
May
sure.
May I? Cindy, how many people have elected to Title IX hearing?
In the 4 years I've been here, we have one complaint that went to hearing and one complaint that is moving as if it will go to hearing.
But you've had numerous other complaints. Yes.
Yeah.
Most people do not.
Pam highlights, she highlights something very specific, that something can proceed through the formal complaint process, but the parties can choose together to move to an informal process if they don't want to have to go through the pain and anguish of a live hearing.
Pam, this question's for you. Through your extensive work, you have seen quite the history of Title IX and the evolution. But do you think we have been effective in preventing gender discrimination, specifically against women? And if not, what action still needs to be taken to do so?
I have seen a lot, but I can't say that I've followed swimming as an individual sport well enough to say that.
I'm sorry, women, not swimming.
I'm sorry, women.
Women. Do you think
have we solved the problem? No. We're on the road. We're on the road. What we've seen is that problems of discrimination are cyclical. You always have to be vigilant. If you aren't, you are going to have problems. People have old habits, and these changes are expensive. And you first of all, you've got to change women themselves to want to participate in sports. There's been a massive change in that area since 1970. So I would say this is one of the most successful pieces of social legislation that I know of. We have done better in eliminating the discrimination in this area, I believe, than we have in discriminating against racial minorities by far. But that doesn't mean we've eliminated all discrimination, not at all. But we do need to take responsibility, whoever we are. And I see more and more people doing that. Parents take responsibility now, many of them encouraging their daughters, like their sons, to participate in athletics. And if they have a skill and an interest, supporting both of them. It's just a sea change. And that shouldn't be underestimated. But that doesn't mean we're done. Pat us on the back and say, okay, you did this for us, now we can all go forward and there won't be any problems. We just have to move on to the next generation of leaders and the next generation of issues. And excuse me, I do wear hearing aids and can't hear consonants very well. So thank you.
No, you are fine. You are fine. Alrighty, though, we are close on time. I want to be cognizant of our attendees. We will share this in a recording, and so you are welcome to ask additional follow-ups follow-up questions when that recording comes out, and I'm sure I can pinpoint those to the correct audience as needed. And honestly, thank you both so much. I mean, we have had a year-long celebration of celebrating the 50th anniversary of Title IX. This was an excellent follow-up. Particularly as a new follow-up, we've talked a little bit about athletics. Over the course of the year, we've had those celebrations, but it's still good to know a little bit more of exactly what does the legislation looks like, because I think that's sometimes a point of it we miss a little bit in talking through it and being able to talk through that complaint process better. So thank you both so much. I want to thank our listeners again for coming through 12 Titan Talks this year. This is our last one of the 2022 year. But I have seen some of you appear time and time again each month, and that really warms my heart that you continue to keep coming back for these. And just have a wonderful holiday season, however you are celebrating. And I look forward to seeing you again in January. Speaking of athletics, January's Titan Talk will feature Tony Bankston and Mike Wagner talking about the new initiatives in Titan athletics, one of those being wrestling for men and women. So thank you both so much and have a wonderful holiday season, everyone. Goodbye.
Thanks all.